Hey everyone, Harry here to talk about Donald Trump's $100 million claim against the Department of Justice. And that might seem like breaking news, but in fact, as is generally the case with Trump and his legal maneuvers, there is nothing new under the sun. So what is he claiming the $100 million for? The Mar-a-Lago raid. And why is he claiming it? All the old reasons. But this is in somewhat new garb. So let me explain how it works. Okay, so first and foremost, this is right now an administrative claim, meaning it is directed to the DOJ itself to decide the merits of it. There's a limited avenue for appeals should he lose, but right now he's given it to the DOJ. Why to the DOJ? Because, and we have to review very quickly, principles of sovereign immunity. Dating back to the King and Magna Carta days and before, the general notion is that a sovereign, a government, a king or queen are sovereign in their own courts, and they get to decide. The courts are their creation in a sense, and they get to decide what they will be liable for. This has come up repeatedly, you may remember, when the question has been whether Trump was acting within his scope of employment when he allegedly did various things, but including defamed E. Jean Carroll. Now, why does the government ever, if it's up to them, why do they ever consent to suit? Because government is a functioning part of a modern international community, and nobody would contract with them if they just said, if you have any damages, too bad. So the FTCA, Federal Tort Claims Act, provides, we're waiving for certain kinds of claims. And basically they are sort of negligence in the scope of employment. That's why it comes up with Trump. If somebody does something totally crazy or an intentional tort or whatever, you can sue them, but don't come after us. We haven't waived for that. But somebody in a workaday case, a post office employee who gets in a car accident, that's going to be a regular tort that you can bring under state law, and you'll find that the federal government has waived. Okay, so that's the notion. Now, under the Federal Tort Claims Act, if you want to file a claim, first steps first, you've got to file it to the agency in question. You've got to give them a shot to respond and to clear the decks of good ones versus bad ones, maybe give reasons. And then there's still a review as a sort of safety net in the courts, but it's limited. And the review is for whether there was sovereign immunity. Okay? So now come Trump, he needs to not have sovereign immunity here. And it is the same claims and diatribes as ever. Basically, they came in and ransacked Mar-a-Lago and never told him. Some of these claims were the basis for his getting the complete separate cause of action from Cannon and the whole big mess, because what we're really talking about is an absolute by the book, other than it's the former president, standard pedestrian, nothing new here search. But so what's Trump going to say? Well, he claims there are certain torts under Florida law that were violated. One, for instance, is abuse of process under Florida law. But under Florida law, you have to show that somebody intentionally, maliciously ignored the standard process and the like. That'll be the sort of substance he'll have to get to if he is able to show or persuade the DOJ in the first instance that there is no sovereign immunity. Now, for that part, there are two basic claims that are on the table. There are the two important exceptions to sovereign immunity. The first one is for an intentional tort. So if somebody is doing something intentionally as opposed to negligently, that you can't bring under the Federal Tort Claims Act. more importantly is the discretionary function claim. And the idea there is the courts are not supposed to second guess decisions about policy and operations by the people in individual agencies. That's not what the Federal Tort Claims Act is about. So in order to try to get back through that, what does Trump say? He says, well, Merrick Garland and Chris Wray's decisions were not grounded in social, economic, and political policy, meaning they didn't just make a policy call of, sure looks like there's fruits of a crime here, let's go in. But in clear dereliction of constitutional principles, they applied inconsistent standards and a clear intent to engage in political persecution. Sound familiar? So what he's trying to say, it's a little ironic because it's the very thing that the Supreme Court said you can't think about when the president's involved, why they were doing it. But he's trying to allege that rather than a normal law enforcement decision, this was just political persecution, and therefore it wasn't even discretionary. This is a bit of a non sequitur, but it was a requirement under the Constitution that they not approve the raid. And what else did they do wrong? According to Trump, they were required under DOJ internal policy. By the way, DOJ internal policy is basically never a basis for getting a tort claim, or just vague principles. They should have told Trump this was happening and told Trump's lawyers this was happening. Of course, with a run-of-the-mill search, which this really is, imagine the principle that says you are required to let the target know about this and let the attorneys know about it. It would be, a clear invitation. Please go destroy all your evidence now because we are coming in. So the underlying claim is bogus, but even the claim for there being no sovereign immunity is bogus. And there's a relationship, but for now, just to be clear, focus on the argument that rather than making a sort of standard law enforcement decision, the DOJ, FBI, even Garland and Wray made a political prosecution decision, and therefore, for current purposes, there is no sovereign immunity. All right, I believe it's something like 30 days for the DOJ to consider this screed, and I see no argument that has a chance of prevailing. So we can expect the DOJ to say, sorry, you haven't made out a claim of that this isn't covered by sovereign immunity, denying the claim, and then Trump will have some very limited rights for appeal. So, not much cost for him, just recycle the old screed stuff and put a little label to say Dear DOJ rather than Dear Court. Make the same claims, but really they don't fly on the facts, and they don't fly on the law, and they don't, in addition, fly on the doctrine of when the United States has sovereign immunity, as it does here. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.